All right, I'd like to welcome everyone here to tonight's presentation of Restoring Reproductive Rights. My name is Solomon Gibson III, and what I hope to offer you for this presentation is a new way to think about this issue and present you with some facts, some lesser known facts that really aren't put out there that I think people should know about once they discuss or want to push back on this issue. Now, what I hope to accomplish in this presentation is offering up uh, little bits of information that will be useful whenever you're in discussion for this issue with your legislatures or in conversations with leaders or institutes that individually may serve to help you in discussing this issue, but collectively, what I'm going to propose to you is a solution to the issue, an overall strategy that if you're truly ambitious, you may be able to use in restoring reproductive rights nationwide. Now, the first thing to note is that in this, what we are looking at for the goal is complete bodily autonomy, that women have a decision on what to do with their bodies at every stage. The assertion is that reproductive rights exist under current constitutional law. Nothing has to be changed. Legislation, no federal laws. Congress can continue with its current configuration, that no changes have to happen. What that means is that this could be put in place right now, that it exists under current constitutional law. Some key points that I think should be known in no particular order of priority. The Constitution speaks to the rights of the people and does not differentiate those rights by group. The Constitution does not say that this group gets this many rights and this other group only gets those rights. It's nowhere in the Constitution does it say that. State government is the biggest threat to people's rights. Historically speaking, that has been absolutely true. There have been many arguments that the federal government is the threat, but there is little evidence. If the federal government is the threat, then look to the states, because that's what composes the federal government. And that has been proven throughout history. Slavery was a states' rights issue. Women voting was a states' rights issue. Current bans on books, states' rights. The current abortion issues, states' rights issues. When it comes to people's rights, states are the greatest threat to those rights. Under constitutional law, states cannot make people. So if your leaders and legislatures of the state have told you that they are going to turn fetuses into people, they cannot do that. They cannot make those things that are not recognized in the Constitution as persons into them and give them constitutional rights through state edict. They just can't do it. And that's what you can tell your legislatures. Number 4, states' recognized interest in prenatal life is a legal fiction. This was essentially created in Roe v. Wade, but does not exist anywhere in the Constitution. It was crafted by that court to allow state intervention, but the states have no recognized interest in prenatal law and prenatal life as far as the Constitution goes. They made it up. 5, it doesn't matter whether the fetus is legally a person or not under current law, the end result is the same. The woman can have it extracted. I will expand on this by the end of this presentation and show how that is absolutely true. Number 6, compromise is not really possible on this issue. If anything in the current situation, if anything is proven, is that last one is absolutely true. If you are a faction that believes that abortion is killing babies, and you truly believe that, then you cannot stop fighting for that to be stopped. You must constantly fight to have that eliminated. And if one faction cannot compromise, then what does that leave for the other faction? You either capitulate and go on to something else, or you fight just as hard for what you believe in and what is right. Now, those are the 6 key points that I will be wrapping into this presentation and expanding on each one of them. Currently, you've probably heard that what's going on in fighting for this issue, there are 3 strategies that are being proposed. The first strategy, federal laws and policies that Congress will be able to make up some, will create some law or restore Roe v. Wade. State constitutional amendments, we hear about that quite a bit as each state drafts legislation or an amendment in their particular state that restores reproductive rights. And the third strategy, of course, has been a longstanding Equal Rights Amendment. Those are the 3 most common strategies being used. Currently under federal law, it's undefined. Right now, there is no specific legislation. Proposals are a restoration of Roe or something similar with a shorter ban on abortions, usually around 15 to 20 weeks. That's a general proposal for a federal law or policy. Excuse me. The Equal Rights Amendment. The Equal Rights Amendment has been around since 1923. What it states is equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. That's the Equal Rights Amendment as it stands right now. State constitutional amendments generally are around this range. Basically, every individual has a fundamental right to reproductive freedom without limitations, and a list of various things. It tends to be fairly comprehensive, and you'll find the states that are passing this amendment are tending to draft legislation similar to this. Those are the details of the 3 strategies. And now I'm going to give pros and cons for each one of those strategies. Now, these current strategies, all to varying degrees, will address the problem. One common requirement for these strategies is that people have to vote. What that means is that they require people who support, leaders who support each one of these for them to attain passage. Now, some of the pros and cons, beginning with federal laws and policies. Pros, it's a national strategy which would restore reproductive rights in every state. The cons to it is that it's compromised legislation. What we're looking at is complete bodily autonomy. As long as there is state intervention, states will try to circumvent whatever the law or policy is. And this would allow that based on what we've heard as far as policy goes. There's unlikely passage of this in the current environment. You need a certain number in the Senate so that it avoids a filibuster. And currently, the House isn't going to pass anything with a narrow margin. Depending on what goes on with the elections, it still may be difficult unless there is a Senate supermajority to gain passage. The third con is that it maintains state intervention. As I stated before, as long as states can intervene, states will intervene. We've seen that time and time and time again. They will attempt to obstruct in any way possible. The ERA has its pros and cons. The Equal Rights Amendment is broader, more comprehensive national effect. It has longevity. Once you have an amendment, it's difficult to reverse it. The cons is that it's currently in legal quagmire. What that means is that the Equal Rights Amendment has existed in one form or another since 1923. It has never been passed. In 1979, its first deadline, it came close to being ratified, but missed the mark by, I believe, 3 states. It was given an extension on that deadline to 1982 and missed that by about 3 states. It would not attain. It has not. What has happened, the legal quagmire that comes into play is that some some people believe that thanks to 2020, when the last state was ratified, the Equal Rights Amendment from 1979, is that it should be ratified, even though it took that amount of time and went past its deadline, that it finally got the necessary 38 states to be ratified. And their argument is that everything should apply even before that time. They want to go from that original 1979 Equal Rights Amendment and say, we've done it, finally. The argument against that is that it is past the deadline of 1982. And consequently, what would happen is that obviously, if it were ratified or made an amendment, is that it would be challenged immediately in court by any state or states that chose to, would take it to the Supreme Court. That, of course, would undoubtedly say that it was unconstitutional because it passed a deadline. Several states have wanted to rescind. One state had a deadline on its ratification. So the idea is that in the court, you'd say, well, what about the states that want to rescind? Do we recognize those? What about the one that had the deadline? Do you recognize that? If that's the case, then you can't ratify this because you don't have the necessary number of states. In any case, those arguments would go on for at least a decade. And that's where the Equal Rights Amendment is right now, unless they're working behind the scenes and figuring some stuff out. The Equal Rights Amendment says nothing really about state intervention. And with that remaining unclear, states have worked around every rights amendment that has ever been offered in the Constitution. Every single one of them have been worked around by the states at one time or another from the very beginning. And we know this, of course, because slavery. They had to work around everyone's rights. And this would be no different, because as we found, if states, they worked around Roe v. Wade, spent years doing it. And that's number 3. This is the con. These are the downsides for the ERA presently. Amendments to state constitution. Now, they have a lot of pros. There's the ease of voter involvement. All you have to do is get it on the ballot, vote for it. There's a high rate of success with passage. Every time one of these has made it onto the ballot and voted by the people in that state, they have passed. These rights amendments have absolutely passed, even in quote unquote red states. The amendments tend to be fairly comprehensive. They tend to cover everything, as you saw early on. And just like with the amendments of the Constitution, these amendments tend to have longevity. The cons for amendments to state constitutions is that they're not national. It's a state-by-state basis. And we've seen what happens when people have rights in one state but don't have rights in another. We've already seen that picture. The original one ended in a civil war. It's also unclear the effect on state intervention. While they're comprehensive, it's still unclear as to what states are able to do in getting involved in rights. State governments can be quite clever. So of the 3 strategies, 2 of them have never been enacted. The Equal Rights Amendment has never been enacted. There has never been any federal policies or federal laws or federal legislation that has ever been passed out of Congress to deal with this issue. And so the track record with those 2 are 0. The state amendments are the only ones, as I pointed out earlier. Now, with all of that out there, what is being proposed here is a more comprehensive strategy. This is the Restoring Reproductive Rights flowchart. I made it myself. And what I began to question was the state's intervention. What the flowchart points out is a legal strategy that requires none of what has been talked about before. It is a strategy that seems to have never been tried. Now, it should be understood that the only strategies that have ever had any effect on this issue have been legal ones. As I said, federal government has never done anything about it. The president has never done anything. There have been no executive orders that have addressed this. Only legal strategies have even begun to address this issue. Roe v. Wade is the only thing that has ever done anything in the 100, at that time, 150 years, give or take, that the issue has existed. I think from the original time, it was actually almost 95 years, 93 years, something like that, where nothing was done until that legal precedent was set. So that's what this is. It is an attempt to craft the law in a way that restores these rights. And to begin, it starts with a question, a constitutional question, and that is, do states have the constitutional ability to deny access to safe, approved treatment for a group's unique medical condition? Do the states have that power? If the answer to that question is yes, the second legal question that could be asked is, can states practice discrimination in using disability? Now, if the answer is no, this leads to a 14th Amendment violation. The 14th Amendment guarantees equal protection under the law and anti-discrimination. But if we continue along this line, if the states do have the power to discriminate, then they have the power to directly determine life and death for any favored or disfavored group of people. The idea being is that if you are allowed to deny groups access to their medical needs, then you can pick any group that you like. Right now, this particular access is for women. What prevents states from deciding that men can't have vasectomies, that Black people can't have access for sickle cell, or Jewish people for Tay-Sachs, or geriatric treatment, or pediatric treatment? Based on this, they could do that. And if that's the case, the ERA becomes even more essential. And considering how close it was to passage and ratification before, it would garner even greater public support with an anticipation of restoring rights. Because to eliminate that power from the state, you would eliminate the state's ability to deny abortion access. And that's what happens on the other half. Do states have the constitutional ability to deny access to safe legal treatment for a group? If the answer is no, then the state cannot deny access to abortion procedures for any reason beyond patient safety. The reason for that is that the procedure for terminating a pregnancy is safe and legal. And pregnancy, by legal definition, is a medical condition. It can't be anything else. Fetuses are currently under constitutional law, not people. So a pregnancy can be nothing more under law than a medical condition. And if we are allowed access to treatment for a medical condition, then you're allowed access to the treatment for terminating a pregnancy. And automatically, if that is in play, rights are restored. However, if states defy that legal determination, they decide that despite what the law says in this case, they're going to continue to do what they're doing. And that's absolutely what they're doing right now. Then they are in violation of the 14th Amendment, just as before. And that's where these 2 points converge. As stated, the 14th Amendment guarantees all people equal protection under the law, as well as it's an anti-discrimination amendment. And we've seen that time and time again. Crafted in 1867, I believe, it was crafted to protect newly freed slaves from abuse by Southern states. Now, the challenge to the court would be any woman would go to court and challenge any state that had any level of restriction on access to terminating a pregnancy as a violation of their 14th Amendment rights of equal protection and anti-discrimination, based on the idea that no other group has these kind of restrictions. Men don't have any restrictions on anything that they want to access. No other group has any restrictions, not a single one. It's left up to the doctor and patient. So that means that women are not equally protected under the law. And technically, well, factually, they are being discriminated against. There's some debate about that because of conservative court ruling in 1993 that I believe could be disputed depending on how you made this argument. But the court challenge for a violation of equal protection and anti-discrimination of a specific group of people, in this case, women, would lead the states to mount a legal defense on this particular issue with the only legal defense that they have. And that is recognized interest in prenatal life. In fact, that was stated in Dobbs. As you saw earlier, states do not have that under the law. Recognized interest in prenatal life does not exist in the Constitution. Because, well, prenatal life doesn't exist in the Constitution. And so, given that, that would be the state's only way to challenge this. 2 points could be challenged in that determination. One, you can challenge the designation of interest, recognize interest as being broad and vague, particularly right now, since the courts have tossed out the trimester guidelines. The word interest now has no meaning whatsoever. It can go anywhere from the states shrugging its shoulders and saying, well, that's interesting, to state governments doing exactly what it's doing now. Egregious intervention in reducing the ability to have access to 6 weeks or eliminating it altogether. The definition of interest is just that broad, as to have no meaning whatsoever. And that can be challenged in court. What can also be challenged, of course, is the designation prenatal as having no recognition in the Constitution, because it just is not there. Prenatal life does not exist anywhere in the Constitution. And so where does that come from? With these two challenges, a determination has to be made about the fetus. A specific determination. What is it under the law? Is it a person or is it not a person? Because those are the only two designations that matter as far as constitutional rights go. If the answer is yes, the fetus is a person, and this is going to go back to the point where I originally stated that it doesn't matter whether the fetus is a person or not. If the fetus is designated as a person, that fetal person has all the rights and all the rights that we all have, thanks to the 14th Amendment. But it also has all the limits on those rights that we all have, because one group of people cannot have more rights than another group of people under constitutional law. My rights are the same as yours. And if that is the case, one person's rights end where another's begin, no matter the need. My rights end where yours start. I can't do anything to deny you your rights. And it doesn't matter what my need is. If I want your blood and I need it to save my life, I can't take it against your will. And nobody can make you give it up against your will. Not a single, they can't even test you to see if we're a match against your will. And so certainly a fetal person cannot have access to a person's entire body for 9 months if you or I can't get a drop of blood out of you. And that is a limitation if the fetus is designated as a person. And if so, the fetal person can be removed on request to prevent continued violation of both a woman's rights and the 13th Amendment. Slavery. It banned slavery in the country. And what that means is that if a state tells you that your body has to be used for some other reason to the advantage of someone or something else, that by definition is enslavement. And the state is telling you, well, this fetal person needs your body to continue to exist. By definition, you have just enslaved that person. You've said their body is now in service to some other person until they no longer need it. So given these two violations, rights are restored. That's if the fetus is a person. And you will not hear anyone say that. I have not heard anyone say that really anywhere. No one's making that argument. So let the states make the fetus a person. This is what would come into play. Under the current Constitution, without changing a single thing. Now, if the fetus is not a person under constitutional law, which it is not right now, that's exactly, the fetus is not a person right now, then pregnancy is legally a medical condition. And a patient would be allowed access to medical treatment for that condition. Rights are restored. So whether the fetus is a person or whether the fetus is not a person, under current law, it can be successfully argued that you could remove the fetus. And there's nothing the states could do to stop you. That is the legal strategy that is presented here, consolidating all the information previously that I believe would solve the issue once and for all, this very argument. Now, some things to remember in concluding all of this is that personhood cannot be granted or denied by states, completely unconstitutional. They can't say you're a person, you're not a person. There's nothing that really gives them that power, at least not since post-Civil War times. They just can't do it. States targeting women, denying them access to safe, effective services for their medical condition violates the 14th Amendment, equal protection and anti-discrimination. As I said, there's been an argument about the anti-discrimination, but I think there's been a parsing of that, and depending on how you wish to argue it, that it can be, that the Brady decision can be worked around fairly easily. Third, states forcing women to use their bodies to carry to term is a violation of the 13th Amendment, which is the amendment that banned slavery in the country, which I just explained. And so, a few action items you can take with you that may be able to serve you, at least in part, is to contact your legislatures, leaders, and institutions, and let them know you're aware that the Constitution does not allow states to bestow personhood. State governments will try to get away with what you let them get away with, and that's what they're kind of doing. They're saying, we can do this, and so you should be afraid of that. Well, they can't do it, and you shouldn't be afraid of that. They just cannot do it. Inform them that forcing a woman to carry to term against her will for any reason is enslavement, a clear violation of the 13th Amendment. I recommend you try that on your legislatures. You ask them that question and see what they have to say. You can insist any compromise legislation must limit state and federal intervention in the procedure for terminating a pregnancy. And I urge you to use that term, procedure for terminating a pregnancy, a medical procedure. To the level of typical standard oversight exercised with all other surgeries and medical treatments. The reason for this is to make it comparative. The idea here is that you don't want this particular procedure to be treated any different than any other medical procedure. Be it a vasectomy, be it liposuction, be it whatever it is, cosmetic surgery, is that medical procedures that are safe and legal are between doctor and patient. The only state involvement in any of those are for the safety of the patient. And that would be the woman. So insist and inform them that any compromise legislation that your leaders work on limit state and federal intervention. Because that is, if anything in a compromise, I would urge that that be the most important thing above anything else in this legislation. States should not be involved except at the typical level that they're involved in anything else. Now, for those of you that are truly ambitious or have resources or connections, legal challenges. As I said, my overall strategy is a legal challenge that, based on information, can work, even though it is not out there. The legal challenges can include whether states can deny access to safe legal medical treatment, and if they can discriminate in that treatment. You can use a flowchart strategy for the violations of the 13th and 14th Amendment as placed out there, particularly the 13th Amendment. And lastly, you could support the use of this information and strategy through Planned Parenthood, the NOW, and other organizations that are fighting for this issue. Tell them that there is a strategy, that there are several ways to do this, that for whatever reason, they don't seem to be either aware of, or I don't know what the answer to that is. But it can be a strategy that you can use. Contact them, let them know what I have just told you. And so, if there are any questions.
Questions from the audience there? I've got some questions.
What we're doing now is we have to ask people to type it into the chat. So
I understand.
ask people to type their question in the chat.
I understand.
You need to ask them to do that.
Oh, I'm sorry. If you have any questions, type it into the chat. I've just been informed. Zach, this is my first time doing this.
I have a question.
Okay.
There's no such thing as a compromise on this, but I mean, isn't the number of weeks the compromise? And I mean, even for people who support,
Yeah.
Even for people who support abortion, is there a number of weeks? I mean, you wouldn't want to have an abortion at 39 weeks, or I mean, there's got to be a limit to when you stop even considering abortion.
And I would make the argument is that's not up to you or I. One, there are several real truths here. One, no woman is waiting till the last day or even the last couple of weeks or even the last month to terminate a pregnancy. At that point, it's not a pregnancy, it's a C-section. It's a cesarean. You don't find women that will do that with healthy pregnancies. You don't find doctors that will do that, or their teams by that point in time that will do that with healthy pregnancies. That's a fallacy. It's just not done. And so the idea of limitations on anything, then we can question, shouldn't we have limitations on guns? Shouldn't we have limitations on all sorts of things? Because on the off chance someone will abuse the opportunity. The fact is, we are supposed to be giving women the same responsibilities that we all have. And honestly, if you look at the statistics, that's just what they do. They don't carry a pregnancy to term, go through 7 or 8 months of the hard stuff, and then in the last few weeks decide, you know what, I'm done here.
But all these Republican, I guess, constitutional amendments or something, they're putting in a very low number of weeks to determine, you can't, after 6 weeks, you can't have an abortion. What if it was something like after 16 weeks, which is in some states, I'm not sure if it's North Carolina, or 20 weeks or something, where there's no doubt that the woman is pregnant, and it's, but right there, you can come up with a compromise, and the people who are anti-abortion can say, yes, okay, we've prevented abortions after 16 weeks and feel good about it. But people who, want the ability to abort have up till 16 weeks, which is, I think, pretty good.
I would make 2 points about that. One, we just had a compromise, 50 years. Roe v. Wade had a compromise of, for the first 13 weeks, a woman could abort practically at will.
Okay.
For up to 24 weeks, pretty much the same thing, although there could be some state intervention. After that, states could literally pretty much ban abortions.
Okay.
We just had that 50-year compromise. What happened during that compromise? The certain factions, states tried to eliminate abortion clinics. First, they sectioned off abortion clinics into their own areas, which was actually unnecessary. They took them out of regular hospitals and put them in their own clinics. Then those clinics could be targeted for not only protests, but for overregulation.
Right.
And literally be completely bankrupted out. And you can
Right.
go to Texas and see
Texas,
just
right.
what that is.
Yeah.
And so the idea of compromise, well, there was 50 years of compromise, and it did not stand. Because if you have, once again, if you have a faction that can't compromise, what does that leave for you to do? They will never be happy with any sort of compromise. That's why you're getting the 15, and the goalpost is always being moved. 20 weeks, 15 weeks, 6 weeks, et cetera, complete ban. And that's why I say compromise is not possible, because it's been proven that it is not possible. The closest thing to an even Steven compromise was probably Roe v. Wade. And they couldn't do it. They couldn't let it go. The second thing I will say about that is that if you have the right to bodily autonomy, and we all should, then how could you put limits on that? I've been thinking about slavery. What would we say if Black people early on were only free 6 months out of the year or 9 months out of the year? Is that tolerable? Would we be saying that it's okay because 9 months they could run around free and do whatever they want, but for these 3 months, well, certain states can decide they got nothing. Well, we actually already had that too. And so I kind of see the parallel is that you can't give people rights to come and go. It's kind of an all or nothing, and should be an all or nothing. And women deserve to have complete and total rights, like you and I, like you or I have, between they and their doctor. Yes, we have another question.
Yes,
Yes, isn't it true that Ruth Bader Ginsburg later said that she did not agree with the Roe versus Wade decision. And she said that the more solid ground would have been to base a ruling on the 14th Amendment. Are you familiar with her argument?
Somewhat familiar. She did. Um, and she was right, at least as far as it goes. It wasn't this particular argument. It was an equal protection argument for the woman. It made no establishment of what the fetus was or was not, except that everyone knew that the fetus wasn't the person. And so she said it should have been ruled that way, but she also had a little codicil as far as it goes. And that was she felt that Roe v. Wade actually went too far for what it did, and that the society and the culture should have kind of been allowed to wean itself into these things. The idea being is that there should have been discussions from the court through with political leaders and various things like that. So she was rather moderate on this, although she agreed it should have been ruled on the 14th Amendment and not the more amorphous right to privacy. Any more questions? Well, as I said, this is a strategy. Those are the action items that you can use. Contact your legislatures because that's what they will always tell you, no matter which of these strategies you're using. Now, I'm not asking for anybody's money. Like some of the institutions are, you don't have to send me a darn thing. As I said, what's within your power is to contact your legislature and let them know that you are knowledgeable that what they are saying is not necessarily the power that they have. I think that is one of the best things you can do in challenging what these leaders are trying to sell us all, because they just don't have that kind of power. Oh, another question.
Oh, yes. Will you be able to make your slides available to the participants who came in through Zoom?
I'll have to speak with my technician.
Okay, but you're open to that.
I am.
Okay, great,
Totally.
great. We'll talk about that.
I assume you have the information that would be able to send it off. Excellent. And I hope that you will share this knowledge as much as you can. If you have any questions, what would be the best way to get in touch, actually?
Do you have your email address?
Yes, although it's a little lengthy.
I'll put this address in the chat.
And send the presentation to folks, put, Solomon's name and address, name and email address.
Well, yeah, that's fine. And I hope you will share it or send any questions you have. This has been something thought about for a while. And at this point, I've talked to attorneys, I've talked to many people much smarter than I am on this issue and gotten a lot of input on what I have crafted here. And I have yet to find any of them say that it couldn't work. Now, the frustration is that no one is actually using it for whatever reason, but they can't deny the logic of it. And as I would point out, this does not require any changes in what we already have. This could be fought for and implemented in a matter of weeks, depending on your determination and what's going on out there. Congress doesn't have to change one whit. The president, well, doesn't necessarily have to matter if he abides by the law. Your local legislatures don't really make any difference here. The Constitution says what it says, and it says everything that I have put out here. It's just been put together in a more logical way and in a slightly different way than our system is used to using it, but it's there. So if you want to get in touch with me, if you have friends out there that you can share this with that want to discuss this further, I will be happy to talk with anyone or send you any information that you require. I want to thank everyone who tuned in and who are here, and I hope to talk to many more.